Board of Management of the Canadian National Institute for the Blind to present the position of CNIB on the subject of human rights.
David.
Mr. Chairman, to begin, I'd like to thank you both as a volunteer member of CNIB's Ontario Board and as a blind individual for this opportunity to speak to you on what is a crucial issue in our view. I would indicate at the outset two things. The first of which is that I believe all the members of the committee have a letter addressed, I believe it's to me, from the Ontario Federation of the Physically Handicapped, a federation of some 37 organizations which deal with various kinds of disabilities. A letter endorsing the position articulated in our written brief, and I ask that in pursuance of what Mr. Mercer's just said, that this is indicative of the kind of support for our view that exists amongst all kinds of disabled persons, not merely persons with a visual handicap. I'd also ask at this time, Mr. Chairman, and I'm sorry there aren't enough to go around, but in the spirit of equality which we're promoting here, I'd like to ask the clerk to pass around to the various members if they'd prefer not to read our brief in print, they have the choice of reading it on a cassette tape or in Braille. And I'd ask the clerk to pass those around, and I apologize that there will not be enough for absolutely everyone, but we'll be pleased to provide you extra if such are needed in the future.
Thank you very much. Pass around.
As I said, it's demonstrative, I hope, of our efforts towards equality and our concerns about the equality of blind and other handicapped persons. Mr. Chairman, to begin, I'd like to mention a point which may come as a surprise to some. The biggest problem, very often, with being handicapped, and in the case of the CNIB is concerned with being blind, is often not blindness or the handicap. A blindness, a visual handicap, or other kinds of disability is frequently one which one can learn to adjust to through training, one can learn to cope with, and ultimately achieve a substantial, if not total, degree of independence, self-sufficiency, and self-worth. The biggest problem, very often resulting from blindness or other handicap, is the well-intentioned cruelty which many of the public unintentionally or unknowingly impose upon us. The pity, patronization, discriminatory attitudes, and condescension which handicapped persons know to be unfortunately almost non-stop component of their life is in fact the biggest problem they face. A handicapped person, in the case that we're discussing today, a blind person can learn through specific training to overcome the limitations imposed by their blindness, such that blindness no longer functions in most cases as a, quote, handicap. In fact, it can become what is at times merely a marginal aspect of one's life, compelling that one read in print or in Braille rather than print, that one use a guide dog or a cane to get from point A to B rather than using one's eyes, but nonetheless accomplishing substantially the same things as a sighted person would. Once one has achieved this degree of independence, however, the problem that is confronted by the majority of handicapped persons is the fact that the public is not often ready to accept us as equals, not by malevolence, but by uninformed or misinformed attitudes, underestimating our capabilities, by fear of handicapped persons, you might call it the, quotes, freak syndrome, not perceiving a handicapped person as just another normal human being. And this is manifested in several ways, many of which are frightening and are harmful. Job discrimination against the disabled is something which the public is only now becoming conscious of. The fact that once you've learned to do a job, once you're ready to go out in the marketplace and be competitive, you find that the only barrier you've got is not your blindness or other handicap, but is the employer who doesn't believe you can function. The housing and other physical facilities which landlords may not be provided to rent to you because a blind person might be a health hazard. People don't want to look at someone who's got cerebral palsy because it might be somehow unpalatable to look at in the opinion of some. Education systems are accessible primarily to non-disabled persons and only to a limited degree to disabled persons. And of course, as we all know, most buildings are not accessible. These are a function of an attitude that the world simply doesn't contain handicapped people, or those handicapped people are not really going to be out there trying to get jobs and are trying to get into housing and trying to get into buildings. Our concern is generally with this attitude, and CNIB as well as other organizations have taken many steps both with public education and lobbying to change this. Where this kind of problem with public attitudes becomes perhaps the most frightening, the most requiring of action, is something which is addressed in the Charter of Rights, which is before you. Handicapped people in the struggle for equality and equality of opportunity find that not only do people discriminate in the access to jobs, buildings, facilities, services, and housing, but find that in fact legislators, persons passing laws, have also experienced the same negative attitudes towards the handicapped and have passed laws which are in fact discriminatory. And accordingly, the major thrust of our presentation is that it is necessary that included in Section 15 of the Charter of Rights, the so-called Equality or Non-Discrimination Clause, be referred to as a protected class mentally or physically handicapped persons. That we're not looking at this as a means of getting jobs, of getting housing. That's something which is dealt with at the provincial and federal human rights code level, and we're active in lobbying for that. But here we're concerned with not just human conduct that's discriminatory, but legislation which discriminates. Why should we be included in Section 15? Why are handicapped people entitled to equality before the law and to the equal protection of the law? To begin with, I'm sure you all come to the conclusion yourself, and you've heard from other groups, as the clause is presently drafted, it is unarguable, unquestionable that handicapped persons are not entitled to equality before the law. By this exclusion, it perpetuates in our Constitution an attitude which, as I've mentioned, is prevalent in society. Some notion of handicapped people as second-class citizens, people who need to be taken care of, not given independence, protected, not given the opportunity of equality. Inclusion in Section 15 would be, for the handicapped would be consistent with what is the supposed intention or the stated intention of the government with respect to the Charter of Rights. I refer to a statement made by the Minister of External Affairs, Mr. Mark McGuigan, in speaking at a public forum on the Constitution some weeks ago in Toronto, when I asked him about the handicap issue. He had said that the Charter of Rights was central to the government's package of reforms and that equality for all minorities is central to the Charter of Rights. If that is the intention, then that intention is thwarted by the present proposed Section 15, because equality for all minorities is not provided. Equality for some is the rubric or the essence of Section 15 as it stands. And it is a respectful submission of the Canadian National Institute for the Blind that if the intention of the government is to in fact give equality to all minorities, and given the fact that there are some hundreds of thousands or millions of handicapped persons in Canada, all told, there is a minority that requires protection. That is not disputed, and so the government's intention must only be manifested, it is our view, if we're included. Moreover, if the purpose of the Equality Clause is truly to grant equality, one must look at its wording. It provides equality for certain minorities. In other words, it involves equality for some. And equality for some, I submit, really means equality for none. It means that there are two levels in society, one level of people who are entitled to equality and one level who aren't. And when you have two distinct classes such as that, the term equality has been stripped of its meaning and rendered more of an illusion. Accordingly, if equality is the goal, then it must be equality for all. And all must include, we submit, handicap. Now, as I said previously, Mr. McGuigan, in his statement in answer to certain questions I put to him about the handicap issue, acknowledged that the handicapped are not included, and raised the question whether handicapped people need protection in a Bill of Rights, whether they need egalitarian liberties. And his statement was, is what the handicapped need are jobs and access to buildings. And these are economic, not political or egalitarian liberties, and are not the kinds of things that are required in a constitution. Now, in a world that was not our own, where economic liberties were generally being entrenched, I'd be prepared to address issues such as jobs and architectural access in the Constitution, but we're not going to address that today because we recognize the constraints under which Canada and the Parliament are operating. However, I would like to address the statement that Mr. McGuigan made, speaking at that time on behalf of the government on the Constitution. He said that what handicapped people need is not constitutional protection for equality. And it is our submission that Mr. McGuigan's view is inaccurate. And in fact, when I pointed out certain things that I'm about to point out to you, he explained that he'd never heard of them before and would probably need to rethink the whole issue. Legislation, as I said, in many instances discriminates against the disabled. You've heard this before, but I believe that we'll be the first handicapped group that will in fact itemize examples. Many statutes across Canada, both federally and provincially, which provide that everyone is entitled to a minimum wage when they're in the employment situation, provide exemptions for handicapped persons. That is discrimination under or in law with respect to a legal right to a certain minimum wage. Certain statutes explain when that right is to be administered and when not. Certain don't. They merely say that the government has, or a minister has the power to give a license to allow an employer to pay less than minimum wage without giving reasons. This is not equality. This is discrimination, in our view. Many statutes across Canada dealing with eligibility to sit on juries exclude blind persons from the right to serve on juries. Now, there are times when vision may be needed to serve as a juror. It is not our view that every trial should always be open for a blind person to sit on a jury. However, there are, and I, as a law student and soon to be a lawyer, I can speak with some limited knowledge of this. There are many cases where vision is not necessary, and probably the lack of vision may be a benefit to a juror. And so legislation which just blanketly excludes blind persons without reference to their abilities or inability to function as a juror is discriminatory. The marriage legislation in Ontario provides in Section 7 that a marriage license cannot be granted to someone who is mentally defective. Doesn't refer to whether their mental limitation is so serious that it would impede their ability to understand or consent to a marriage agreement. It merely excludes someone who is mentally defective from the right to be married. Such, in our submission, is discriminatory. The Family Benefits Act in Ontario, a piece of welfare legislation, provides in one section that certain handicapped persons who are in institutions and entitled to certain welfare payments may, by executive order, have those payments paid to a civil servant, a director of the institution or whatever. I don't have the details here, unfortunately, rather than to the handicapped person themselves. It doesn't ever require that a handicapped person's right to receive welfare can be impeded only if that person is incapable of managing their own affairs. It merely says any handicapped person, so that if it is a person who is perfectly capable of handling that money capably, nonetheless, their right can be taken away by executive action perfectly legally under a statute of the province of Ontario. Such is legislation which discriminates. The Education Act in Ontario, Mr. Chairman, provides that a handicapped person, whether physically or mentally handicapped, can be excluded from the right to go to their local elementary school if they are, quotes, incapable of profiting by instruction, close quotes, and then a separate school system is established to deal in those situations. Now, education is a big and serious issue, and I don't intend to address it in its totality here. But I think it's fair to say that a provision that says that only where handicapped people can't profit from instruction, only those people are excluded from the right to go to their local schools. If it's a non-handicapped person who for some other reason is incapable of profiting from instruction, the statute does not exclude them from the right to go to their local schools. Such is unequal treatment, such is discriminatory, at least prima facie in our submission. Other legislation, and I'll only deal with other legislation briefly. British Columbia's schools legislation, Section 107, Subsection 5, provides, Mr. Chairman, in certain circumstances that an employee of a Board of Education who is totally and permanently disabled, and I couldn't find a definition in the Act of that term, cannot be hired by the Board until they lose their disability. Now, certain disabled persons cannot function in a teaching environment, but others can. So such a blanket exemption, if applied against any person with any disability, would be, in fact, discriminatory. And I bring to your attention that blind persons are functioning both in Canada and the United States in the teaching profession. I'm not sure if that act would include blind people within their definition of total and permanent disability, but there's the risk. There's the risk. And that's discriminatory legislation with which we're concerned. The Immigration Act, passed by the government some couple of years ago, in Section 19, Subsection 1, provides a higher burden on a handicapped person who proposes to immigrate to Canada. If that handicapped person can meet all the requirements required of a non-handicapped person, able to support themselves, finding a job, etc., they still must prove to a medical officer that they will not be an excessive demand on health and social services. There's no requirement that other persons wanting to immigrate have to prove that they won't provide such a demand on health and social services. Such separate treatment, not applied to all immigrants, is discriminatory in our view. I would submit that there are other laws that do discriminate, but I think that these are sufficiently illustrative to respond to the suggestion that either we need no constitutional protection, the legislatures can take care of it themselves. This is evidence of how the legislatures have taken care of handicap rights to equality. And moreover, Mr. Chairman, I think that it rebuts the suggestion made by Mr. McGuigan a couple of weeks ago in response to my question that handicapped people simply need rights to jobs that can be provided by statutes. They don't need constitutional rights. Moving on, Mr. Chairman, I would say that there are other reasons why we need to be included in the clause providing for equality. We are a substantial minority. We're not talking about a very small number of people. We have 30,000 clients registered at CNIB, and Dr. Foreman can provide you with information of how many other visually handicapped people, as well as other handicapped people, may well be out in the community. Some have suggested that there are 1 in 10 persons in Canada are handicapped in some way, and therefore would benefit from the kind of constitutional protection we're talking about. There are a couple of arguments that have been raised primarily by spokesmen for the government. In one instance, I think it's the Minister of Justice, Mr. Chrétien, against handicap inclusion. One argument that he made was that we shouldn't include it now because it's hard to define the term handicap. We should wait till we can come up with a definition and put it in through an amending formula. Well, with respect to the Minister of Justice, I don't believe that position is tenable. Firstly, if this committee requires information on how to define handicap, having looked over most Canadian statutes that contain the word and have various definitions over the past few days, I've found that some statutes don't even bother defining it, but those that do have been able to effectively. And having done some research on this particular issue myself, I'm more than happy to supply you with information to show that definition of handicap would be no problem. Secondly, leaving it to an amending formula is not a realistic proposition because the process of amendment, which requires a lot of lobbying, a lot of time, a lot of money, would not be, in our view, probably manageable by handicapped persons, being, for the most part, served by not altogether wealthy nonprofit organizations who live off of charity donations in many cases, and handicapped people themselves often living at or below the poverty line. So the amendment process will simply not be open to us as a practical matter, I submit. But more importantly, definitional arguments I don't think are persuasive in saying that handicapped persons not be included. Many terms are included both in this Charter of Rights as proposed and in the British North America Act 1867, which are much more vague than is the word handicap or mental or physical handicap. Will you note that in Section 15 they refer to discrimination on the grounds of religion? Mr. Chairman, I'd invite anyone to define what religion means. in a comprehensive manner. I think that term, while we know that certain religions, Judaism, Christianity, Buddhism, are religions, but there will be many borderline cases where we don't know if those groups are religions or not. But that hasn't precluded the drafters of this charter from including religion. You'll note in the British North America Act that under Section 91, criminal law is given to the federal government. We've had 100 years of litigation over what criminal law means in the Constitution, but that never stopped the framers of the BNA Act from including the words criminal law within that constitutional document. And finally, in Section 1 of the proposed charter, the words reasonable limits are used, which I would submit are incredibly harder to define, if not impossible to define, than are the words mental or physical handicap. And accordingly, I don't think one can simply avoid the issue or duck the issue because of definitional problems. The final reason for that I'd like to articulate for including handicap in Section 15 concerns an argument that some have raised against it, namely that the costs occasioned by including the handicap would be excessive. I have several responses to that argument. Number one, I would ask what those costs would be. I'm not altogether clear, and I'd submit that there probably aren't that many. Intuitively, nothing really comes to mind as being excessively costly. Secondly, I'd submit that unless this committee is going to go through the process of looking at every liberty enumerated in the Charter of Rights and go, how much will this one cost? Should we include it? Is it too expensive? Unless we were to do that with every single liberty, then there's a certain inequality to simply looking at one group, namely the handicapped, and say that they will be excluded on the basis of a cost argument. And so if that argument is presented before this committee, I'd ask that you bear that in mind. And finally, if that argument is presented before this committee, that is that including handicap would be too costly, I'd ask you to bear the following argument in mind, or the following point in mind. To say that the cost is too excessive is to assume that handicap inclusion is the absolute lowest priority of every government in Canada, that we've spent every last dollar of revenue we've taxed and collected, and that there's no money left. If you were to look at the priorities of the various governments, provincial and federal, of spending, you might find that there are others that are lower priority than handicapped equality, and you might find that it might be worth including the handicapped in the Constitution and perhaps let some more inconsequential programs go by the boards. I don't think it's fair to simply say it costs too much, therefore we can't do it. Moving very quickly through the other points of ours, because the other points we've made are ones which other groups have made as well. We recommend not only that handicap be included in the Charter, Section 15, but we would prefer it if the Charter read something like equality before the law without discrimination, without unreasonable discrimination or without unreasonable distinction. Unreasonable discrimination meaning without restricting the generality of the foregoing, and then you can put a list of protected classes and include mental or physical handicap. The reason we suggest this is because if an equality clause is truly to give us equality, it must give us equality with all others, and that is the way to do it. It's been suggested before this committee that perhaps it would be best to simply say equality before the law without discrimination, period. No reference to a list of protected classes. Now, that would be preferable to what's proposed in the present bill, but in our view, it is not desirable for the following reasons. Firstly, it would mean that some thousands and thousands of dollars would be required going to court, appealing up to the Supreme Court of Canada in order to get a precedent decided that decides whether handicap is a class protected by the clause. To avoid that kind of cost, delay, and uncertainty, it could be easily included now without any such cost. And secondly, Mr. Chairman, the fact of the matter is if we have to go to court and argue it, there's no guarantee that we will be included by the courts. The courts take a very restrictive view of civil liberties in general, and handicapped civil liberties is a new area in Canadian law, and therefore the risk is that we may never get in, even after an appeal process. So the only way of guaranteeing our rights is by including us. Briefly, Mr. Chairman, we recommend, as is mentioned in our brief, that the words equality before the law and equal protection of the law are far too weak a means of protecting egalitarian liberties. You've heard this from other groups, and we endorse the views that have been presented, namely that the courts under the present bill have interpreted those words to not provide egalitarian liberties. And they've done it in an unequivocal way. And there's these words, even though there's one word that's different, these words are far too close to the existing Bill of Rights to ensure anyone that the courts will use this as a strong lever to nullify discriminatory laws. And it's our concern that once it's, again, the same amendment argument goes, if we get bad precedent, we have to go through the amending process, and we've seen in the States with the ERA battle, how many years and at what cost that fight is, and that there's no certainty of success. More importantly, it's our view that the courts have a tradition of taking a very restrictive view of civil liberties. Now, that's not by way of criticism or by way of anything less than respect for the members of the judiciary, but it is something which is nonetheless true. And I think that it will be necessary, and it's our submission, that it will be necessary for strong direction to be given to the courts through very specific wording, directing them to invalidate discriminatory legislation. Moving to the end of my presentation, Mr. Chairman, it's our submission, as you'll see in our brief, that Section 1 should not govern either Section 14 or Section 15. It's our view that there should be no circumstances when where the right to an interpreter, which a deafblind or just a deaf person may require in court, should ever be taken away. Why is it either in war or emergency that a deafblind person on trial should be denied an interpreter to know what the case is against them? It's too basic a denial of natural justice. Moreover, when should discrimination, unwarranted discrimination, be permitted? At wartime, at peacetime, in the case of an emergency? It's hard to imagine a situation where it's justifiable, and therefore we've recommended, as have other groups, that Sections 14 and 15 be absolute rights, rights not subject to Section 1. Alternatively, if that point of view is not acceptable to the committee, it is our submission that the wording in Section 1 is far, far too broad. You've heard all the arguments before. We can only reiterate them, that Section 1, labeled by some as the Mack truck provision, will in fact make the rest of the Charter of Rights a virtually worthless and impotent means of protecting civil liberties. In particular, the generally accepted view of the public with respect to handicapped persons is that they are often not capable of taking care of themselves, not capable of maintaining a job, not capable of self-sufficiency. And therefore, the kinds of laws that I've discussed previously that are discriminatory would be, under Section 1, generally accepted in a free and democratic society passed by these kinds of parliaments. And accordingly, if Section 1 remains and if Section 15 is still subject to it, it's our view that Section 1 must be very narrowly constrained to protect minority rights, and in particular handicap rights. Finally, it's our submission that Section 29 sub 2, which provides that the Equality Clause will go into effect later than all other parts of the bill, should be repealed, simply because there is no good reason in our view why egalitarian liberties should be delayed. If anything, they should be accelerated. In conclusion, I'd like to make the following points. Our concern is that there is a danger of misleading people if the Charter does not include the handicap. There is a danger that people will believe that in Canada, under such a provision, egalitarian liberties are truly safeguarded. There is equality for all. Without handicap inclusion, such is not the case. And it is not only unfair to handicapped persons to deny them equality, but it is a risky venture for the public to be misled into the believing that all minorities are protected when they are, in fact, not. Our concern, as I said at the outset, is dealing with public attitudes. Public attitudes are something which we must battle at various levels. At the constitutional level, we are battling public attitudes as they are manifested through legislation. And this is a battle which is both serious and crucial. Finally, I'd submit, I would close, Mr. Chairman, by saying that there's an oft-stated adage that justice is blind. In fact, it's a cliche. Our concern is, and the underlying concern of this presentation, is that while justice may have had the opportunity to experience blindness, we are asking for blind persons as well as other handicapped persons to be given at last an opportunity to experience justice.
Thank you very much, Mr. Lepofsky. Inasmuch as Mr. Lepofsky and his group have given us a thorough understanding of their brief. We have a few minutes left. We have another group that are to be here at 10:15, and the House sits at 11. I'm wondering if I could have some agreement with the committee that we have 3 questions and that we could probably terminate at 10:20 or 10:25 and have our time at 5 minutes rather than the 10-minute round. Senator, or Mr. Epp?
Mr. Chairman, I was going to make the recommendation. Mr. Lepofsky has been excellent in the presentation and on this topic. Just 2 points. One, he kindly offered us to make information available, redefinition of the handicapped. I believe I've got his words correct. And I would ask the committee to request of Mr. Lepofsky that he make that information available to us. I don't think it necessarily has to be appended to the minutes of this hearing, but that the information be circulated. Secondly, I would recommend, Mr. Chairman, that instead of the 10-minute round for the witnesses this morning, that you reduce it to 5 minutes, and if there are any questions after that first round, we'll leave that with the chair.
Thank you very much. Mr. Is that agreed? Mr. Donahue?
Gentlemen, I'm very happy that good fortune...
Senator Donahue, I'm sorry.
I'm very happy that good fortune presented me this morning with the opportunity of sitting in on this committee as a substitute for one of the regular members, because I am very pleased to have had the opportunity of hearing the very excellent presentation made by Mr. Lepofsky. I was interested to hear the illustration that was given of discrimination possibly against a juror, a non-cited juror, because in my experience as an Attorney General for many years, I was once faced with the application for appointment as a Crown Prosecutor by a blind person. And he was an excellent lawyer, good student, and so on. But he was asking to be made a Crown Prosecutor and to conduct criminal prosecutions. And I ask you to believe that it was a matter of real difficulty for me to determine whether or not that handicap, in fact, was of a nature that detracted from his ability to do the fullest and most complete job in that particular capacity. I want to say that I did, in fact, appoint the gentleman, and he conducted himself with great credit for a number of years. But I wonder if the person who suffers the handicap can appreciate the difficulty that a person in the position in which I was at that time might have in determining whether they are in fact discriminating against that person because of a handicap, or whether they are in fact merely endeavoring to see that their obligations and responsibilities are discharged in the best possible manner. I don't wish to say too much, or to ask too much, because I think your presentation was indeed excellent, and that the point of view of the organization for which you are speaking and of the people whom it represents has been exceedingly well put here this morning. I would like to ask this simple question. Do you believe that the position of the handicap will be substantially improved or enhanced if this procedure is followed? The procedure that is suggested is to entrench certain rights. You have indicated that you find the suggestions inadequate, insufficient, and in need of substantial amendment, and that those amendments should be specifically directed towards the class of person for whom you are speaking here this morning. Do you feel that the position of the handicapped is going to be very much improved and very much enhanced if this procedure is followed with or without your suggested amendments?
Mr. Chairman, to answer both your points, understanding the fact that an employer, a service provider, must go through a very difficult analysis and thought process to decide what one is capable of is something which is only too well understood by a handicapped person, because before someone like myself decided to go into law school, I had to make that same analysis. So it's something which not only have I thought about, but I'll think about it before any of my potential employers have thought about it. And it's a difficult process. The Equality Clause, if it included the disabled, would give us a right in the instance where a legislator had went through that thought process and in fact made a wrong decision in the passage of laws which ended up discriminating, would give us a right to appeal that to the court and to argue that it's an unreasonable distinction that's been drawn against handicapped persons. So I guess my first point would be, Mr. Chairman, that this would provide a means, a mechanism for handicapped persons, interest groups, and other interested groups to challenge legislation which is discriminatory. If these provisions are not put in, it would signal to the disabled that it is the prevailing view in Canada that handicapped people are not entitled to equality before the law, that the kinds of discrimination that is experienced by any handicapped person in their everyday life is in fact a pervasive view which has been articulated through the actions of the framers of a new constitution. On the other hand, if this provision is included as we've proposed, several benefits would accrue, I submit. The first is that next year, being the International Year of the Disabled Person, would show Canada doing what could be the best possible move to ensure disabled persons' equality, which is to pass a constitution enshrining their rights. Secondly, it would be a signal to the Canadian people that handicapped persons who in the past have either been a forgotten minority or a lesser class of citizenship, and again I say this wasn't intentional or out of malevolence, but it's happened nonetheless, that it would be a signal to the public that a new era has dawned, and that as deeply felt a feeling is to be presented to Canada as can be expressed through a Charter of Fundamental Rights, is acknowledging this liberty. And as I said, some of the more odious legislation, some of which I've enumerated, would be amenable to attack. I mean, I do know that certain lobbying has succeeded. In Ontario, lobbying by various groups has inspired the Ontario legislature, after 100 years of having similar jury legislation, to finally change it. It's about to get royal assent. But the process of getting that reform has taken a long time. Had we had an equality clause, we could have had it adjudicated upon and possibly won the matter much more quickly. And it was only, frankly, out of luck, in our view, that this amendment ever came through.
Thank you very much, Mr.
Chairman, I'd like to ask just one more question.
I'm very sorry. I'm afraid I'm going to have to be a little tough. You've used 7 minutes, almost 7 minutes, and we have Mr. Althouse and Senator Connolly. Mr. Althouse?
The other evidence seems to suggest that disabled and handicapped people suffer an unemployment rate of between 70 and 80%. And I note in your remarks this morning that you mentioned that employers who don't believe you can function is one of the big handicaps you're facing. Is this the greatest difficulty faced by blind people, that is access to opportunity to function? Will the amendments proposed encourage this access to opportunity, in your opinion?
I would agree that the access to jobs and other facilities is perhaps the greatest problem. As I said, it's the attitudes of the public that's the greatest problem, and perhaps that's the worst manifestation of it, aside from the other manifestation that I mentioned, namely legislative discrimination. Our proposals would not require employers to hire a handicapped person who can do the job. That is something which is dealt with Human Rights Code, and I'd say on the side that we're involved in lobbying, along with many other organizations, for amendments to such laws. And I'm personally involved in that, so I can give you a lot of information on that if it's necessary. It would, however, have two beneficial effects in the employment situation. The first is, by entrenching this in a Charter of Rights, it would, as I've said previously, be a signal to the Canadian public that handicapped people are entitled to equality, and that's an educational effect which would be of profound importance and help. Secondly, there is the possibility. Now, I'm not sure if I didn't mention this in my list of discriminatory legislation because good law students told to use your weakest arguments at the end or drop them altogether. The Federal Human Rights Code provides protection for the handicapped in the area of employment, but it doesn't refer to the handicapped in the areas of housing or access to services or goods. I'd say that that is a form of discrimination. As you know, the Canada Human Rights Commission has recommended amendments to cover that. I'd be interested in knowing if we could build a case that that we're getting unequal treatment under the Human Rights Code, since in certain provinces we're not included at all in the code, and in other provinces we're only given partial protection. But that is a case which, while I'd love to argue it personally, I'm not overwhelmed by the fact that it would be successful. But the most important point is that the educational effect to the public, and that laws which are a barrier to education, that are a barrier to equal opportunity, and that signal second-class citizenship for handicapped to the public, would be attackable by us.
In this regard, the slow movement towards access to jobs and access to equal access to buildings and services, I note one of the supporting groups, the Federation of Physically Handicapped for Ontario, has mentioned in supporting documents that were passed out along with your brief that they make the point that Section 29 in the proposal that we have before us places a restriction on the implementation of such rights. Under Section 29, it says that there will be a 3-year waiting period, that they won't come into effect any sooner than the amending formula. What is the reaction of your group to this waiting period? Your group is, or handicapped individuals seem to be the only group that have been singled out for this by this particular subsection 2.
I would say that it's a concern of ours. I mentioned that the delay, if anything, is undesirable. We'd prefer to see an equality provision protecting us in effect 10 years ago. However, I would confess that it's not our major concern. Our major concern is getting into the bill in one form or another at all.
Thank you very much, Mr. Donahue. Senator Connolly?
Thank you, Mr. Chairman. First of all, we're all very happy indeed to have the CNIB here, because over the years this organization has done a tremendous amount, and I think perhaps the witnesses might agree that the important feature of that work is the fact that they have helped so much to promote the integration, particularly of blind people, into the community, into society, and into all phases of Canadian life. And this is a great achievement on behalf of CNIB and of the people who work with them. Could I also, on a personal basis, congratulate Mr. Lepofsky for the very lucid and very comprehensive statement that he has made. I predict that he is going to be a very good lawyer. I would hope that he might become a member of Parliament, but I tell him immediately that he will not be the first person who is without sight that has been in the House of Commons. And I don't say that as a joke. There are lots there that physically see, but perhaps mentally not. That does not apply to the Senate. There was a man on the conservative side, I beg your pardon?
So blind as he who will not see.
Well, I can't hear all that. Okay. Well, I know they're doing it, but then that's a House of Commons practice. We don't do that in the Senate either. We have had people without sight in Parliament. Trevor Morgan was here back in the early 70s on the conservative side, and I remember very well a man from, I think, the Kootenays in British Columbia. I can't think of his name, Mr. Esty or Mr. Ely or something like that.
Senator Connolly, Dr. Dr. Foreman, I think, wants to ask you a question. Would you permit that?
Yes, sure.
I was just going to thank the Senator for his kind remarks about the Institute and about Mr. Lepofsky, and I also would like to thank the committee from the point of view of letting my guide dog in.
Good. But I think he may have been the first in Parliament, this man whose name escapes me, and for this I apologize. And there's a great story of an exchange between Mackenzie King, R.B. Bennett, and this man one time over the Doukhobors that is one of the great stories on the records of Parliament. What I'd like to ask Mr. Lepofsky is this. You have been talking, and the other groups that have represented the handicapped have been talking about the importance of integrating the handicapped community into the normal stream of public life. And I think great strides have been made as education has advanced, as public education in this respect has improved. And I don't ask you this as a trick question, but I wonder whether by segregating the handicapped, you aren't, to use your own words, signaling to the disabled that they are forever a segregated group. Would you not be stronger? Would your position not be stronger before the law? Even before the laws, these provincial laws that you have criticized here. If the non-discriminatory clause applied equally to you whether you are handicapped, equally to me whether I don't happen to be physically handicapped, but maybe mentally and so on, wouldn't it be a better thing in the long run not to have a special category set out in a constitution which presumably is to last for a long, long time?
I can answer that question, Mr. Chairman, briefly. Firstly, I thank you for your compliments, and with respect to my potential future in Parliament, my immediate concern, perhaps a little myopic, is that I have another 4 bar exams to write, or I'm going to continue being a law student for a lot longer. But firstly, on the question of integration generally, particularly I must say under the leadership of the new management at CNIB with Mr. Mercer, and with general trends that are taking place, CNIB as well as other organizations are becoming much more active in adopting integration of handicapped people into society as a goal, phasing down and phasing out segregationist programming, and lobbying for equal rights legislation. This is demonstrative of our kind of work. So while there has been segregation, in fact, somewhat imposed by handicapped organizations over the years, this is something which is changing, and I'd say the 3 gentlemen in front of you representing the CNIB are hoping and striving to see that change continue and accelerate. As for whether it's somewhat discriminatory or special treatment to mention us expressly in the Equality Clause, I have 2 answers to that, 2 brief points. The first of which is, as I mentioned in my general remarks, if you don't put us in expressly, if you merely say that discrimination is equality before the law without discrimination, period, then you're leaving it to us to have to litigate, go to courts, spend thousands of dollars, and try our luck. Firstly, I don't think we could afford it too readily. Secondly, we're at risk that we will lose. Frankly, having read a great deal of civil liberties case law, because that's a particular area of law that interests me in Canada, our courts have a very restrictive, very narrow treatment of civil liberties, and they only enforce them, as evidenced by the treatment of the 1960 Bill of Rights, when there's no way out, and even then they don't. So that my concern is that we may well not win such a case, no matter what the intention is of the Senate, no matter what the intention is of the House of Commons in passing this bill. The only way we can be sure to be in, speaking from a legal point of view, is to put us in. Saves us money, improves our chances.
Thank you very much, Mr. Lepofsky. At this time, I would like to thank you on behalf of the committee, Mr. Mercer and Dr. Foreman. I want you to know that your dog is most welcome in here. I was going to say something, then I thought better of it after. I have great respect for dogs. In your brief, you've raised some problems that I'm sure none of the committee had heard before, at least I hadn't, and we appreciate you being here. Thanks very much.
Thank you.
Mr. Mercer, did you have something you wish to say?
Yes, Mr. Chairman, I know that our president, Mr. Dick Smith from Winnipeg, would like me to express thanks and appreciation from CNIB for all of you today to take the time and listen to our point of view. So thank you very much.
Thank you.
I would like to call now at the witnesses table the representative of the Word Federalist of Canada.